Welcome. We're going to go ahead and get started. My name is Dean Reuter. I'm a Vice President and Director of the Practice Groups at the Federalist Society. It's my pleasure to welcome you here today and to be our moderator for today's events. My job, I think, is to introduce folks and then get out of the way so we can have a good and fruitful discussion. This event is sponsored by the Claremont Institute, and it's also co-sponsored by my organization, the Federalist Society. So thank you all for being here. We're discussing the question partisan bureaucracy, a two-word question. The IRS, the DOJ, and the future of political activism. We're going to have a round of opening remarks from each of our speakers in turn. We're going to go right down the list here. We're going to hear first from John Eastman, Professor John Eastman of Chapman University Law School, where he was formerly the dean. He's going to speak to us for 10 or 12 minutes, talking about his experience in answer to all these questions. I know that the bios are available to you, so I'm being very brief in my introductions. We'll hear then from Cleta Mitchell. She is a partner in the Washington, D.C. office of Foley & Lardner. And along with Dr. Eastman, she's also a contributor to a book I recently have out with John Yoo. In fact, the first three speakers are all contributors. So I don't know what that might say about the book, but we're going to hear third then from Hans von Spakovsky. He's probably familiar to you. He is of the Heritage Foundation. He is also the author and co-author of this book, Obama's Enforcer, Eric Holder's Justice Department, that he wrote with John Fund, and he'll probably speak about that a little bit as well. And then finally, we'll hear opening remarks from our guest, Robert Weiner, from right here in Washington, D.C., and he is, I give special thanks to him for joining us because he will be taking something of an opposing view, and in recognition of that, we're going to give him a few extra minutes of time at the outset. But then we're going to have some lively discussion and questions from the audience. So with that, Professor Eastman.
Thanks, Dean, and thanks to the Federal Society for co-sponsoring this. I'm with the Claremont Institute. I'm a senior fellow there, and I run our Center for Constitutional Jurisprudence. Our mission is to recover the principles of the American founding. They seem to be slipping more quickly through our fingers of late than they have been in my lifetime. Our president of the Claremont Institute, Michael Pack, is here in the audience, so I got to be on my good behavior. Look, I'm here in town today because I argued the True the Vote versus IRS case, which kind of was the catalyst for this panel. But Cleta's going to take up more about that case and the broader things of what's going on the IRS than I am. So I just want to touch on a couple of things. Our argument this morning began with reference to a Sixth Circuit decision just 2 weeks ago, where it said it's one of the most dangerous things one can imagine in a republic when the government's citizens are targeted because of their political views, particularly because of their political views criticizing the government. And then the opinion concluded with a recognition that the Department of Justice has a long and storied tradition of being above partisanship in its advocacy and its devotion to the rule of law, all of the laws, not just some selective application of them. And then it said the lawyers in this case have failed in meeting that standard. That's pretty hard words from a federal court of appeals against the Department of Justice in those IRS cases. But it's not just the IRS and the DOJ, and it's not just this administration. I want to be very clear. This problem we're witnessing now, perhaps on hypersteroids, has been a long time in the makings. It goes back 100 years to the notion that if we get the people out of the notion of governing and get experts into our administrative agencies, they'll do a better job. And the last thing you want if you've got experts in the agencies is for them to be checked by unexpert opinion in the electorate or ordinary citizens. And this progressive movement change in our body politic is now we're seeing the fruition of it. And it's, like I said, not just in the IRS and the DOJ, but it's in almost every agency in town. In fact, those that want to join us in our Article 1 bureaucratic accountability or bureaucratic tyranny project don't have to look long before you find lots of targets of opportunities once you're aware of the problem. So rather rewriting fracking rules from the Department of the Interior, a thing that was enjoined by the Wyoming courts last fall, the rewriting of our immigration laws under DACA and DAPA, that issue's pending before the Supreme Court right now. Great things to small things. The renaming of Mount McKinley, contrary to statutory authority. All of the Affordable Care Act rewrites of subsidies and of waivers. even the creation of the contraceptive mandate, which goes beyond the statutory authority that Congress actually authored in the first place. In fact, does the very thing that Senator Barbara Mikulski on the floor of the Senate, when accused that her amendment to the Affordable Care Act would allow for such things, says, that's a damn lie. I wish we would quit doing the lies. That can't happen under my amendment. And then through regulations, they did exactly what she claimed could not do. Treating sexual orientation as sex discrimination and therefore covered under Title VII and Title II, even though lots of efforts over the years in Congress to add sexual orientation to those statutes have failed. Laundering of funds from anti-poverty and anti-malaria programs in Africa to LGBTQ advocacy programs without any statutory authorization. These things go on apace in almost every agency in town, and it's driving political agendas without the accountability of our separation of powers structure in our Constitution. Last term, Justice Thomas, in 3 different opinions, kind of acknowledged the increasing nature of the problem and also acknowledged the court's increasing, albeit late, arrival awareness of the problem. He said in the Michigan versus EPA case, the statute that authorizes the EPA to regulate everything that's appropriate and necessary to protect the environment may well be a potential unconstitutional delegation of power. Then he said we should be alarmed that our deference to administrative agency decisions has emboldened the EPA to make the claims that it did. We seem to be straying further and further from the Constitution. And then in the Amtrak case, Department of Transportation versus Association of American Railroads, he said, we have too long abrogated our duty to enforce the separation of powers required by our Constitution. And we have overseen and sanctioned the growth of the administrative system that concentrates the powers to make laws and the power to enforce them in the hands of a vast and unaccountable administrative apparatus that finds no comfortable home. I would find it doesn't even find an uncomfortable home in the constitutional structure we have. Those are pretty bold challenges to what we've been living with for half a century now, and I think the court is finally coming to the realization that part of its duties is to enforce the structural limits on power that the government, that the Constitution sets out. So we hope to see more of that. And just to make clear what I said earlier, this is not just this administration. I'm reminded of a program we did with the Federalist Society some years ago about the TARP bill, the bailout, and we'll leave aside the question of the constitutionality of that bill in the first place, but it clearly was aimed at providing bailouts for financial institutions. And when the Bush administration wanted to do a bailout for GM, they proposed to amend the statute to authorize it. And when that amendment effort failed in the House of Representatives, they went ahead and did it by regulation anyway. All right, so this temptation of the executive to exercise powers that are not delegated to it, exacerbated by the court's high level of deference to anything they do with their regulatory powers, has really created a separation of powers crisis. And we ought not to be surprised that political actors moving into the void created by that crisis will act politically to further their agendas. All right? The problem is not that they act in accord with their human nature. The problem is that we have allowed the structure that was designed to prevent that to fall by the wayside. And I think it's high time that we try and revive it. Thanks very much.
Well, I want to start by saying that John did a wonderful job in the U.S. Circuit Court of Appeals for the D.C. Circuit this morning, and we're just extremely proud of the job that he did, and Carly Gamble for the ACLJ on behalf of the 38 plaintiffs in that case. You know, it's been a long time. I've been dealing with this IRS situation really since the fall of 2009. And I could spend a lot of time talking about the details of that. But what was particularly rewarding and warmed the cockles of my heart today is that finally there were 2 judges sitting on a bench who really drilled the government. And I loved that because I've been waiting for that for a long time. And they really didn't have a lot to say in their defense. I want to go back to the book that was edited by Dean and John Yoo that includes Liberty's Nemesis. If you haven't bought it, please do. I'm not getting any money from it. None of us. I don't know why we did it, but just a labor of love. But in that book, Dean had asked me to do a chapter about the IRS scandal, and I want to just briefly touch on a little bit of that today because I think it's important, and it's particularly important and relevant for this topic. Where did the IRS scandal come from? Where did it start? And what it really boiled down to, and we know this, and it was an effort and a successful effort to silence political opposition. And that's really what we are facing today. And what is particularly galling to me is that those bastions of the First Amendment, the New York Times, the Washington Post, the working media of this country, they sit idly by when these huge threats and assaults on our First Amendment rights arise day after day after day, and they are the biggest champions for silencing political opposition. Now, something is really wrong when the leading media entities in America today actually support essentially putting duct tape over the mouths of conservatives because they don't like our views. And it's almost as though, every time I drive by the museum on Constitution Avenue, I think, guys, you need to take a chisel and just get rid of that part about free speech because clearly you don't believe in that. You only believe in that one part of freedom of the press. They don't believe in the free exercise of religion. They don't believe in free speech. They don't believe in our right. They don't believe in our rights because they don't agree with us. But I talk about in the chapter, I think it's really important to understand the context. The left, has worked in many decades on eliminating, quote, soft money. Soft money, soft money. We're going to get rid of soft money, corporate money. They mainly want to get rid of corporate money because in their minds, that is business. That is people they're capitalists. Those are people who support free enterprise. So we got to make sure they don't have anything to say, right? Because if we let them talk, they'll just overpower all the rest of us. And I could spend a lot of time talking about that, but that's really been I call them the campaign finance jihadists, and they'll stop at nothing. So they basically get what they want in 2002 with the McCain-Feingold law, passed, let me say, by a Republican Congress and signed into law by a Republican president, which is why I really actually am an independent. But that's not enough. But you know why they were happy? Because for each election cycle thereafter, and this is documented in my chapter because Dean made me document everything, the left was they had the playing field to themselves. Now, in 2004, remember, it was the Democrats who started the America Coming Together, big money, external to the parties, external to the campaigns. They started that. It took until really almost to the end of the cycle, the summer of 2004, before you saw a response by people who wanted to oppose John Kerry. It really wasn't that they wanted to support George W. Bush as much as they wanted to oppose John Kerry, and it was the swift boat veterans and the prisoners of war. I had the honor of representing the POWs who were involved in that. And let me tell you something. Those people had been waiting for John Kerry for 30 years. They knew when he was in Vietnam he was running for president. He showed up with a film crew. Doesn't everybody? And the stories I learned, it was remarkable. But one of the POWs said to me after John McCain had attacked them and told them they should be quiet. One of the POWs who lived in Dallas said, I spent time in the Hanoi Hilton. I think I have a right to talk. But all the money and all the efforts that were poured into 2004 were unsuccessful. You remember George Soros spent all this money, and their America Coming Together, they spent $200 million trying to defeat George W. Bush. They were unsuccessful. Well, that didn't stop them. They went out after that, and they reorganized into something called the Democracy Alliance, and they spent tens of millions of dollars in the 2006 cycle, successfully wresting control of Congress from the Republicans. And in 2008, I go through this in the book about the disparity of money. And one of the things was, you didn't hear all this screaming and yelling about dark money and all this money in politics in 2006 and 2008 because why? Because it was all leftist money. And what drove them crazy, what scared them to death, now here are these three things I say were the harmonic convergence, that in 2009, Obama's taken office. Rick Santelli goes on the floor of the Chicago Board of Trade and starts saying, we need a new Tea Party movement. And people rose up, and there were tens of thousands of people who showed up protesting on tax day, April 15th in 2009, and who and rallies and groups began to form. And then in January 2010, two things happened that literally sent the left into complete outrage from which they have not recovered. And in 2 days' time, two things happened. January 19th, 2010, Scott Brown wins the election in Massachusetts on Obamacare, largely on opposition to Obamacare. And 2 days later, the Supreme Court issued its opinion in Citizens United. And from that, we see this assault that has continued ever since, attacking the ability of organizations, independent of candidates and campaigns, to be able to spend money saying vote for or against a candidate. Now, that is all the Supreme Court said in Citizens United, but you would think this has spawned a situation where literally in November of 2014, there was a vote in the United States Senate on a bill, a resolution introduced by Democrats, which every Democrat supported. Every Democrat voted for it. Every Republican voted against it. It would amend the First Amendment to allow the Congress, the government, to limit and restrict the free speech rights of the American people. And you know what the headline the next day was in Politico? Republicans block campaign finance reform. Now, Kim Strassel has a book coming out about the attacks on the First Amendment. We'll talk a lot about the IRS scandal, but also the Wisconsin John Doe proceedings. Kirsten Powers has published a book on how the left is trying to silence free speech in America. There is really something wrong, and Hans has written about this in the last week, when you have 16 Democratic attorneys general who have a press conference and say we're going to initiate criminal proceedings against people who fund speech with which we disagree. I know from my experience representing the Tea Party groups with respect to the IRS targeting scandal, I had so many calls and so many letters and so many emails from so many people. And I will tell you that I believe very firmly that the IRS has, over the past several years, and this is not even something that's even in a case, and I can't get members of Congress to really do much about this, but I'm absolutely convinced whenever I talk to members, they say, yes, I agree with you. I've heard these same stories. I know this is true. That the IRS uses publicly required campaign finance disclosure reports, disclosing donors, because these are mandated, right? The state and federal laws require disclosure, right? What can be wrong with disclosure? Except when the IRS uses those disclosure reports to identify people to target for IRS audits. And I am telling you, I know as sure as I'm standing here, that has happened. I've heard it too many times to be, for me to believe that this is all just a coincidence. So, look, there's a huge, we have an enormous battle on our hands. The First Amendment is under enormous assault, but only for conservatives. They do not, I have this theory that everything in America that's big, if it's really big, it's not. It's very politically correct, and it is not conservative. I don't care if you're a big law firm, where I work, a big accounting firm, big consulting firms, big business, big labor, big government, big universities, even a lot of small universities, where dissent is and opposing views is simply not acceptable. And I think we all need to be worried about that, because what we're seeing is with the Department of Justice, when Loretta Lynch testifies that they have undertaken an effort to try to figure out how they could prosecute people who deny climate change. Prosecute me. I volunteer. I don't believe it. We know that Lois Lerner sent a database of 12,000 citizens organizations to the Department of Justice for them to review, to determine whether they could prosecute any of those organizations or individuals for engaging in what? Political activity, free speech, free association. So, look, I think that we have a huge challenge ahead of us. And I will just close with a comment. I met a woman a few years back at a meeting. She's a Hollywood writer. Now, you talk about people who have to scurry around under cover of darkness, a conservative Hollywood writer. But But she told me that something I've never forgotten. I just love the way she said that. She said, you know, in Hollywood, we embrace every kind of diversity except a difference of opinion. And I think that is what is being, that is an effort that's attempted to be codified in law, and it is being carried out in the halls of virtually every large institution in our country, and it's our job to try to fight back. Thank you.
All right, well, John Eastman and Cleta, very tough to follow, but I'll see what I can do about that. What's this deal about no royalties on that book, Dean? You know, I got 2 kids in college and a third on the way. Ladies and gentlemen, I'm a former career lawyer at the Department of Justice, despite what you may read in the Washington Post and the New York Times. A year and a half ago, John Fund and I wrote this book, Obama's Enforcer, and I was just shocked at some of the things that lawyers, sources inside, told me. And one of the most significant things that they said, and we didn't just talk to people who were conservatives. I mean, we talked to some very liberal lawyers that we knew, people that I had practiced with, and they all said the same thing. And what they said was that the Department of Justice had been politicized under Eric Holder to an extent that they had never seen before, and that politics and ideology was now driving many decisions on cases as opposed to objective, nonpartisan administration of justice. In fact, one of the lawyers who I talked to, who is a veteran civil rights lawyer, and who had been hired during the Clinton administration, had worked during Clinton, Bush, and the Obama administration, told me that Eric Holder was the worst person to hold the position of Attorney General since John Mitchell, who went to jail in the Watergate case. Now, of course, this Attorney General, after being the first Attorney General to be held in contempt by Congress for refusing to turn over documents about Operation Fast and Furious, which veteran DOJ lawyers will tell you was the most reckless law enforcement operation ever conducted by the Department of Justice, resulted in the death of a U.S. border agent, in the deaths of hundreds of Mexican citizens. And I don't know if you all saw this, but about a couple of weeks ago when El Chapo was recaptured by the Mexican government, guess what they found at his hideout? One of the guns, a .50 caliber sniper rifle that had been sold and smuggled into Mexico through Operation Fast and Furious. Now, you can't just dismiss this as my opinion, because this book is filled with case after case of frivolous prosecutions, criticisms by federal judges in a way I've never seen before, and cases getting dismissed. In just one of those cases, this is a case down in Louisiana, a case against local law enforcement in 2013, the federal judge, after dismissing the Justice Department's case, wrote one of the most extraordinary opinions I've ever read, using words that I've read but never seen in an opinion. His opinion discussed the, this is a quote, grotesque prosecutorial abuse engaged in by Justice Department prosecutors, including people inside the Civil Rights Division where I used to work, and I just love this word, the skullduggery of DOJ lawyers. This included, and this is the way our modern technology is now being used, it included, according to the judge, prosecutors acting with anonymity using social media to circumvent ethical obligations, professional responsibilities, and even to commit violations of the Code of Federal Regulations, close quote. The judge said that GO's actions are, quote, scar tissue that will long evidence infidelity to the principles of ethics, professionalism, and basic fairness and common sense necessary to every criminal prosecution wherever it should occur in this country, close quote. Now, we also got some pages in this book about another great example of the way DOJ has been letting politics and ideology drive its prosecutions, and that's the FACE Act. For those of you who haven't heard of that, the FACE Act is the Freedom of Access to Clinic Entrances Act. That is it's a good federal law. It's intended to stop violence at abortion clinics. But Congress made it very clear when they passed that law it was not intended to stop First Amendment activity in front of abortion clinics, people who want to protest peacefully. And that is how the law was enforced by prior administrations until this one came into office. Since then, case after case filed by DOJ has been dismissed by federal judges in different parts of the country. In just one of them, in 2012, the federal judge made it clear that he thought it was a political prosecution because of the nearly total lack of evidence of any violation of the law and the, quote, negligent and perhaps even grossly negligent, close quote, behavior of DOJ lawyers in not preserving crucial evidence in the case. This led the judge to wonder whether the prosecution was the, quote, product of a concerted effort between the government and the abortion clinic, which began well before the date of the incident at issue, to quell, another great word, you don't see that very often, to quell the activities of the protester. All of you paid for that abusive prosecution because after the case was dismissed, the Justice Department ended up paying $120,000 in attorney's fees to this poor woman who had been targeted by civil rights prosecutors. Why? Because she was protesting peacefully in front of an abortion clinic. Now, that was nearly 3 years ago, and today you might say, well, we've got a new attorney general, and that's probably not a problem today. But just 3 weeks ago, in a decision that I think John mentioned, another federal court issued a decision about, again, the gross misbehavior of DOJ lawyers and the IRS on the topic we've been talking about today. Now, for the past 2 years, one of the Tea Party organizations who tried to get tax-exempt status and who was targeted by the IRS with a huge, long delay, and at one point, the IRS asking them for 3,000 pages of unnecessary information. They sued 2 years ago. They've been in a discovery battle ever since, for 2 years. Why? Because they simply wanted to know who were the IRS employees who were involved in this conspiracy, which I don't think is too harsh a word to use, and what were the names of the other conservative organizations that were targeted. Why? Because they need the names of those other organizations in order to determine whether a class action lawsuit is something that can be filed. Now, the federal district court twice ordered the IRS to turn over this information. The IRS refused to do it. The DOJ lawyers refused to abide with it, and they finally filed a writ of mandamus, which is this old legal term for an order asking the Sixth Circuit Court of Appeals to basically tell the district court not to order discovery. Now, the Sixth Circuit accused the IRS and its DOJ lawyers of basically doing everything they could to delay, avoid, and stop the public from finding out about the IRS's abuse of taxpayers. Now, I want to read you a long quote, and I don't usually do this, but this is really important, and I'll tell you why. There's this quote from the court that epitomizes everything we're talking about here today, which is the government using its power, the bureaucrats using that power to abuse taxpayers, and then to try to cover it up and make sure you don't know about it. Here's what the court said about this. Among the most serious allegations a federal court can address are that an executive agency has targeted citizens for mistreatment based on their political views. No citizen, Republican or Democrat, socialist or libertarian, should be targeted or even have to fear being targeted on those grounds. Yet those are the grounds on which the plaintiffs allege they were mistreated by the IRS. Those allegations are substantial. Most are drawn from findings made by the Treasury Department's own Inspector General. Those findings include that the IRS used political criteria to round up applications for tax-exempt status filed by so-called Tea Party groups, that the IRS often took 4 times as long to process Tea Party applications as other applications, and that the IRS served Tea Party applicants with crushing demands for what the Inspector General called unnecessary information. Yet in this lawsuit, the IRS has only compounded the conduct that gave rise to it. The plaintiffs seek damages on behalf of themselves and other groups whose applications the IRS treated in the same manner described by the Inspector General. the lawsuit has progressed as slowly as the underlying applications themselves. At every turn, the IRS has resisted the plaintiff's requests for information regarding the IRS's treatment of the plaintiff's class, eventually to the open frustration of the district court. It goes on, I won't read you the rest of it, but the point of it was that almost a year later, and this is the end of it, the IRS still has not complied with the court's orders. Instead, it's come to the Sixth Circuit Court of Appeals. The Sixth Circuit said that all of the objections being made by the IRS, and in particular the DOJ lawyers, were meritless. So what is there to deter the IRS, DOJ, and other agencies from doing the same thing again? Nothing. Why? Because none of the people at the IRS have been punished in any way. One of the lawyers I talked about earlier, who was one of the people in the grotesque prosecutorial abuse case down in Louisiana, who was using social media to make anonymous postings about the case, she still works at the Civil Rights Division. Okay, she wasn't fired for that. If I had done that at a private law firm, I would have been out the door the next day. In fact, what did DOJ do about the IRS targeting case? They conducted a sham criminal investigation, assigning it to a big Obama donor who works in the Civil Rights Division. The Civil Rights Division? The Civil Rights Division doesn't normally investigate public corruption. And in fact, this particular lawyer had absolutely no experience in public corruption cases. They assigned it to the Civil Rights Division and to the Public Integrity section of the Criminal Division. The Public Integrity section is the section of justice that investigates and prosecutes public corruption. But they had an obvious conflict of interest. Why? Well, because emails came out showing that in the midst of all this, Lois Lerner had met with the Public Integrity section and had passed over, as Cleta said, millions of pages of IRS documents and information on taxpayers, which it is illegal for them to do under federal law, something that the justice lawyers should have known. And yet they were the ones investigating whether the IRS had committed any criminal acts. By the way, they also refused, of course, that is the Justice Department, to enforce the contempt citation against Lois Lerner. And I have to tell you, that happened under Eric Holder. And I read the 7-page letter, the legal analysis, under which the former U.S. attorney under Eric Holder explained why they weren't enforcing the contempt citation. And what was interesting to me was he totally got the law wrong. The issue in the case, you all may recall, is that the whole question was, did Lois Lerner waive her Fifth Amendment rights when she appeared before the House committee twice, right? And the 7-page letter concentrated the entire time on a legal analysis of that, saying that she didn't actually waive her Fifth Amendment rights when she appeared before the committee. I don't necessarily disagree with that, but what was so interesting to me about the letter was that we now know that she gave a 12-hour interview to Justice Department investigators. And guess what? The District of Columbia is one of the only circuits in the entire United States that has case law that says that if you voluntarily give a statement to the government, you have waived your Fifth Amendment rights. So we know for a fact and a legal conclusion that she waived her Fifth Amendment rights, and yet they refused to enforce that. I will end by saying this. I don't think anyone should expect this problem to go away anytime soon, because federal bureaucrats, particularly a justice of the IRS, are protected by merit service laws that make it almost impossible to fire them, no matter what kind of grotesque prosecutorial abuse they have engaged in. And in fact, the administration has shown that they have no interest in disciplining or otherwise terminating people. When you give people that kind of power, they are going to continue that abuse, and there have been no changes made that will prevent this from happening again in the future. Thanks.
Well, now, even Michael Jordan was only double teamed. So I've been a litigator for a long time, and I've found in litigation that frequently people that accused me of things were of shenanigans or discovery abuse were people who were engaging in it themselves because that's what they did. And so therefore, that's the way it was done, and the accusation must be true. Well, some people don't do it that way, both accusers and accused. And what I'm going to urge today is that the clairvoyance and the telepathy that you've heard here about what's in people's minds, what they're thinking, what they're intending. Ms. Mitchell must have greater mental powers than anyone I know because she knows what people were afraid of, what they thought, what they were trying to do. I mean, come on. Let's stop talking about motives and let's focus on what people did. Okay? Now, let's talk about partisanship. It's been going on a long time. In the Bush administration, there were 3 reports in 2008. One from the Office of Professional Responsibility and the Office of Inspector General in the Justice Department, finding that the Assistant Attorney General for Civil Rights, Bradley Schlossman, considered political and ideological affiliations in personnel actions, including, it said, the transfer of personnel, case assignments, performance awards, and he was quoted as saying that, referring in emails to his tentative plans to gerrymander all of those crazy libs right out of the section. He also called them mold spores. It's pretty creative. And commies. And more to the point, 63 out of the 65 hires had conservative Republican credentials. That's what was found. Second OIG OPR report concluded that DOJ's White House liaison and senior counsel to the Attorney General, Monica Goodling, did the same, and she admitted that she crossed the line. And a third report found that the hiring for the DOJ Honors Program, which had been in the hands of the career employees, in which the political appointees in the Bush administration took over, had been politicized. Those are the reports that's what they found. Now, when a new administration comes into office, it is entitled, within the limits of the law, to set policy, set enforcement priorities. That's why we have elections, right? We bring in leadership in these departments, and they're entitled to set new priorities. The winning side gets to implement its policies, proposition that some folks still don't accept with regard to President Obama. And the career government employees are supposed to carry it out. In the Justice Department, for the most part, that's what happens. Because for a number of reasons. First, in my experience, and I've been in the Justice Department, most of the career, a vast majority, are very professional. They don't talk about politics. The appointees don't talk about politics with them. Second, and more importantly, in the significant preponderance of the areas that the Justice Department deals with, and I'd say at least 80%, there's a continuity from administration to administration. We agree on these things. We agree that we should fight racketeering. We agree that somebody that puts, at least I hope we agree, that pours toxic chemicals into public water should be prosecuted. The Civil Rights Division is not one of those areas of agreement. And voting in particular is charged because, you know, whatever you do is going to favor one side or the other, including doing nothing. The leadership can and they should articulate neutral principles. And they're in fact entitled to articulate neutral principles. And they should stick to them wherever the chips may fall. But especially in the current hyper-partisan environment, we can say two things for relative sure. One is some folks will disagree with the neutral principles. Look, I mean, in the Civil Rights Division, some people think that the enforcement of the civil rights laws, while you should prevent discrimination against everyone, that the civil rights and the voting laws were designed and intended to rectify disparities against minorities, and that should be the priority, not exclusive. Other people don't believe that. That's a difference in principle. But that doesn't mean that there's a partisan difference of principle. It means, or a difference that is partisan. But second, even if you articulate neutral principles and you act on them, a substantial portion of the public isn't going to believe that that's what you're doing. And this, of course, is a central problem with the conspiracy theory, because once you accept the theory, any contrary evidence has the paradoxical effect of reinforcing the theory. Now, another reason the Civil Rights Division is not, this is not an area of confluence of opinion is that historically the people that went there were people that had experience in civil rights. They tended to be people with a passion in that area. They tended to be more liberal. And you know, that creates an issue, okay? The response to that issue is not to stack the personnel process. The response to that issue is to nurture and develop and encourage the culture of professionalism so that the people there carry out the policies the way they're supposed to. Because if you vest the hiring of career people in political appointees over the long term, you will definitely get partisan enforcement of the law. Now, ultimately, I can't tell you what was in the hearts and minds of people in the Civil Rights Division. It's the reason I tend not to talk about motivation. But I can tell you from personal experience about the decision making in the upper levels of the Justice Department. Because I sat in on those meetings, many of those meetings. And it's not the conspiracy many of you think it is. First, in terms of the White House has strict contact policies. I used to enforce them in the Clinton administration. And one thing the White House can't do is call a career employee. In fact, in the Clinton administration, there were only a few people in the White House, like the counsel's office at the top and maybe the chief of staff, who could call anybody in the Justice Department. And the people they could call were the deputy attorney general, the deputy staff, or the associate. You know, they could not go down the ladder. In fact, I remember, and particularly, enforcement was off limits. And I remember once I went to a meeting over at the Justice Department because it was an environmental case and it dealt with something to do with wetlands that was a matter of policy that was important to some people in the White House. And Lois Schiffer, I was sitting there waiting for her to come into the meeting with a bunch of people, and she comes in. She's an old friend of mine, and she looks around, she sees me and says, "What are you doing here? This is an enforcement case." And she threw me out. I'd never focused on the fact that it was in fact an enforcement case. I was focused on the policy, but I left like that because you just didn't do that. And I still think that's the case. And in fact, the upper levels of the Justice Department take a very hands-off approach to enforcement cases themselves. You know, if I was in a meeting with a career employee at the Justice Department, one thing you never talked about was politics. It just wasn't done, even casually. Now, as to what happens in the meetings, I will tell you that the person you most demonize, Eric Holder, was absolutely the straightest shooter of them all. Believe it or not, that's the truth. I was in the meetings with him. There was nobody who was focused more on doing the right thing, who was saying, we can't consider this or we can't consider that. You might not agree with, you certainly wouldn't agree with some of the decisions that were made. But if you were there, you wouldn't object to the way they were made. You know, DOMA, I was in those meetings. You can disagree with the decision the government made about defending DOMA. What was discussed? The law. And what was the standard for when the Justice Department decided not to defend a statute? That was what was discussed, not the politics and who'd be ticked off. So here's my point. I've been litigating for a long time. I'm still a zealous advocate. But at some point I realized that the guy on the other side was just some poor schmo who was defending his client the way I'm defending mine, who had what he believed, I had what I believed. And the same's true of the Justice Department. Vast majority of the people at the Justice Department are dedicated and professional. They don't regard politics. You know, there's thousands and thousands of cases. There's 100,000 employees. There are bad apples. There's no question about it. You can pick out cases where people have done terrible things. I'm a defense lawyer. I know that. I've done my share of accusing in court, okay, in defense of my clients. Many of those Justice Department people think of the political appointees as transients who don't know what they're doing, and they're often not wrong about that. But in my experience, the people I've dealt with will follow the policy dictates that the political leaders set, whether they agree with them or not. Now, the Civil Rights Division became dysfunctional because of, in part, assaults on people's motives. There were all sorts of OIG investigations who determined that these decisions were all within, in both administrations, were within the realm of appropriate discretion. The integrity of the department was undermined because of an effort to skew the workforce politically rather than to elevate the principle of neutrality. So I'm no longer bemused by these conspiracy theories. I think they're destructive. I think they're intellectually lazy. And an organization like this one, which heralds rigorous analysis, I think should look beyond them and try for other explanations. Now, let's talk a little bit about the IRS. Start with an obvious point of agreement. What certain employees did there with regard to organizations, political organizations, was bad governance. It was bad policy. It was bad. The bipartisan investigation of the Senate Finance Committee included that the management was delinquent in its responsibility to provide effective control, guidance, and direction over the processing of applications for tax-exempt status filed by Tea Party and other political advocacy organizations. IRS managers either failed in their responsibility to keep informed about the existence of the applications or failed to recognize their sensitivity. Now, I would say that the IRS conduct was stupid. Not that the people were stupid. The conduct was stupid because it was impervious to the broader issues that were implicated by what they did. And that's in some degree what you want from employees at a lower level. Not to quite this degree, but to some degree. And it was incompetent in the sense that the employees were asked to do something that was beyond their skill set. Your very own apostle, Charles Krauthammer, said, whenever you're faced with an explanation of what's going on in Washington, the choice between incompetence and conspiracy, choose incompetence. That's the Occam's razor principle here, the simple explanation, rather than presume a level of awareness up the food chain that no evidence supports and that's inconsistent with the history of bureaucracies in the real world. And I think the problem with these kind of theories is that they obscure the real issue here. Now, Citizens United loosened the constraints on expenditures for political campaigns. Now, you may well think that's a good thing. I'm not here to debate the First Amendment issue. I think it's a very valid issue to debate. But I do want to talk about the practical consequences, which was it opened the floodgates for massive amounts of money to pour into campaigns fast, 2010. And the court largely dismissed the concerns about the corrupting influence of all this, a view that I think falls somewhere between naive and willfully blind, but the lofty notion was that disclosure would offer protection. And they talked about transparency enables the electorate to make informed decisions. And super PACs under 527 have to make these disclosures. But water, like water fines, a leak in a barrel, good lawyers find the way around disclosure requirements, and they found a way to do it here. Charitable organizations, social welfare organizations, don't have to disclose their donors publicly. And so that was the route. 501c4 says that an organization must be operated exclusively for the promotion of social welfare to qualify here. And the examples they gave were like a volunteer firefighting organization. No, I'm not a tax lawyer, heaven forbid. But I've always read the word exclusively to mean solely, only. But in 1959, the IRS interpreted it to mean primarily. That's the kind of bureaucratic interpretation that people here would probably rail at as imperialism. But in fact, there was an appropriations rider that sought to prevent the regulation that would change it at this stage. But as the IRS interprets the regulation, an organization can engage in electoral politics, get a free ride on the income tax, and not disclose its donor so long as around 51% of its activity relates to social welfare and not politics, not campaigns. Now, perhaps 1959 was a more innocent time, but I, for one, don't want the IRS making this determination at all, period. It's subjective when you're getting into how much is political and how much isn't. But that's what we asked the IRS to do. That's what they were supposed to do. And then you have the deluge of applications and their budget cuts, and what do you expect? I mean, come on. They're going to look for the shortcuts. Now, choosing the Tea Party is dumb for a lot of reasons. It's bad for a lot of reasons. But if the inquiry is whether an organization is primarily engaged in political activity and it's got Tea Party in its name, it's not irrational. Given the mandate and the IRS interpretation of it, problem wasn't so much that they looked there, but that they didn't look in a lot of other places. Crossroads, Priorities USA. Is it right to look into the Tea Party? No. But there is one thing I think that we can say, and that is that the IRS Inspector General has looked at this and said that this won't happen again. If you're going to mandate this kind of inquiry, okay, all you can do, I mean, the better thing is not to mandate the inquiry, okay? maybe we can do that. Right now, that's water over the dam, under the bridge, either or both, okay? So, but they have adopted safeguards. They're in place according to the Inspector General. But here's the point. The point is, again, that it's entirely possible that these are poor schlubs trying to do their job, and they don't do it well, right? And before we look into their hearts and minds and make judgments about what they thought, okay, let's be very, very careful, because someday someone may be doing that to one of us. Thanks.
I have to say I was disappointed. I was hoping for more energy and disagreement in that opening round of remarks, but we do want to get to audience questions. Do we have handheld microphones, Amanda? We do. So in the interest of time, why don't we just go right to questions, and folks can get your responses in with these questions.
Could you, without theorizing on their motivations or what they were thinking, would you describe for us which federal agencies visited Catherine Engelbrecht after she started True the Vote? And please go on and tell us whether you think that the agencies that visited could have been at the behest of Lois Lerner.
Well, is this on? I don't have a conspiracy theory. All I know is what happened to my clients beginning in the fall of 2009. But I got to tell you, I've been doing this before 2009, and after, I knew something was going on at the IRS. And I really didn't ascribe some theory, some conspiracy theory. I just thought that I knew something had changed. And I love the idea about this was a shortcut. This is a shortcut, right? Until the fall of 2009, early January 10, when you applied for a C4 status from the IRS, and I went back and pulled my files. And I put together a memo, and I was just pulling at random. This was not even an exhaustive list. But the average time to get a C4 application submitted to the IRS and a letter of determination back was 3 to 4 weeks. Weeks. So the shortcut was to add burdensome, voluminous questions, time after time after time, requiring, demanding. And if you didn't submit it, as we pointed out to the court today and before, if you didn't respond to these demands from the IRS, they would deem your application withdrawn and you lost all your rights to proceed thereafter. And so then we would have to provide hundreds upon hundreds, thousands of pages. One of the rounds of questions to True the Vote had 102 questions, parts, subparts, sub-subparts, requiring thousands of pages to be submitted. That's a shortcut? That's what somebody's going to, now some schleb is going to have to review that, right? What's the standard of review? I'm not talking conspiracy. I am talking utter lawlessness. And when the Sixth Circuit ordered that the IRS 2 weeks ago turn over the names of the targeted groups so that they could be notified that they had been part of a class that the district court said could be certified, I got 9 notices for clients that I had represented seeking exempt status from the period between 2010 and 2013. So, I mean, I'm not talking motivation. I'm talking about what they did. I'm talking about what Barbara Boxer and Sheldon Whitehouse and President Obama and Nancy Pelosi and the whole list of the cast of characters have said, for what they said after Citizens United. And I'm also going to tell you something. I am really tired of hearing these leftists talk about how this is to stop the flow of this big money in politics. Most of these groups, there were hundreds of them, tens of thousands of citizens. Most of these groups didn't have $5,000 a year. They weren't Karl Rove. They were citizens groups that had no money, but they thought but they saw something happening in their country they wanted to do something about. And that's who this government went after. And just the mere getting of those letters with all those questions, I'll get to Catherine, the mere letters attacking, asking these questions. Have you had candidates come? Please provide the transcript of the comments of any elected official or candidate who's attended your meetings. And on and on and on. Catherine Engelbrecht was she and her husband had a small business in Houston, Texas, and in 2009, she formed a 501c4 King Street Patriots. That was her big mistake. Big mistake, naming that thing Patriots, because if you didn't know, that's a dangerous term. So she named it King Street Patriots, and these citizens would meet every Monday night. And they did this for a couple of years. The IRS successfully basically broke them up, as they did many other groups. There's still about 500 to 600 still active groups in the country, but there would have been more, I think. But they would meet every Monday night to talk about issues and have officials and judges and city council members, and then they decided that they wanted to be monitors for elections. Now, that was her big mistake, because she'd not realized you just don't wade into that water without expecting the full power of the leftist plutocracy to come down on your head. And that's what happened to her. So when she applied for KSP, King Street Patriots / True the Vote, 501c3, to do election integrity monitoring. And from and after the time when Catherine submitted those applications to the IRS, this is a woman who'd never had any real interactions with the government to speak of, other than what most, filing a tax return, et cetera. She and her husband were personally audited by the IRS. This happened in the ensuing 2 years, 18 months really. She and her husband were personally audited. Their family business was personally audited. OSA showed up, surprise inspection. The Bureau of Alcohol, Tobacco, and Firearms came not once but twice. The FBI showed up, and she had 7 different communications and contacts from the FBI, inquiring about people who attended their meetings, what are they doing, trying to find out what they were doing with this patriotic group. So I don't need to hear about conspiracy theories. I know what my clients went through. I talked to one of them last week. They never got their exempt status. They basically just dropped it. But we applied. I was trying to remember when we applied, whether it was 2009, 2010. And when I sent him the notice, they were on this list. So I sent him the notice, and I called him, and he said, he had talked to an IRS agent. The IRS agent had told him several years ago, well, you're on a special list. How about the Z Street case, where the IRS agent said that this organization was formed to promote support of Israel, that the IRS agent told them, well, we're going to have to send this to Washington because your Israel policy is at odds with the administration's. I'm not talking about trying to figure out what the mentality is. I'm just telling you the facts of what these people did and said. It is a record. People know what they did and said. And I'm not so stupid that I do actually believe in rigorous analysis. And I do believe that my rigorous analysis would suggest to me that I can connect some dots. And when Lois Lerner, I'll tell you just one last thing. Lois Lerner said in the fall of 2010 at a speech at Duke University, people are beating on us. They're demanding that we do something. I can't do anything until I see these groups 990s, which they'll file next year, and there's nothing I can do yet. So, Rob, you said that the people at the top set the policy and the worker bees, career people, carry it out. That is exactly what happened.
May I just add a P.S., Ms. Mitchell?
You may.
On the microphone, if you would, since we're recording this.
Just this P.S. because Catherine Engelbrecht is a friend. Robert Bauer, the general counsel for the White House, the former general counsel for the DNC, who became the general counsel for the Obama campaign, sent letters to all of the federal agencies that then visited Ms. Engelbrecht. And he described her organization as a fundamental threat to democracy. Now, Is that a conspiracy? Who would have the weight? I think you all know here in Washington, how do you get federal agencies to work together? It sure wouldn't be through Lois Lerner. But could the general counsel to Barack Obama get that done? In my view, that's what happened.
We'll treat that as a rhetorical question.
Yeah,
But
I want to add something to this.
We'll come to you
And
next,
this notion of the White House no contact policy means the White House was completely hands off of this. There are two things. We get a lot of stories like that. We got the number of extraordinary number of meetings by the head of the IRS over at the White House. Those are facts. That's not conspiracy theory. You can try and understand those facts. But look, even if there was no contact, the president is out on the stump saying this, and I'm reminded, a general walks out in the morning and he says, God, it'd sure be nice if there was some flowers here. Now, he doesn't give that order to anybody in particular. But woe be the battalion commander that doesn't have flowers outside of his office the next morning. Who will rid us of this pest of priest, I'm reminded of, right? The king did not give an order directly to kill that priest, but that priest was killed just as certainly. The notion that there was no White House contact when the president is out there saying, we got a problem, we got to do something about it, the minions in the government do the bidding of the guy at the top when he is making pretty clear statements about what he wants done. And we've got now lots of email traffic back and forth that we're starting to get from the discovery that demonstrates just that. You don't have to spin a conspiracy theory assuming motives. We've got the evidence of the motives in that documentation. And the reason they're fighting so hard to prevent further documentation, I suspect, now here's my conspiracy, I suspect is, we've only seen the tip of the iceberg on this. So if there was nothing there, why are you fighting 5 years later still to stop basic discovery on things that normally get done in your first meet and confer in a litigation? I mean, that's what leads, and if there was nothing there, the right response from government, our servants, we should remind them, is to say, here's what we did. We made a mistake. Judge Santel this morning said, you've admitted unconstitutional conduct and wrongdoing, but you have never demonstrated you're contrite about it, and I think we've seen that today.
let's go to Rob Weiner for your comment.
Sure, let me make a few points. First, the reason there wasn't, this was a shortcut. There was a difference between 2007 and 2010 was Citizens United and the deluge that followed Citizens United. Second, I didn't say that we should stem the flow of money. I was deliberately agnostic on that issue. I said there are consequences, and this is one of the consequences. Third, the issue here was the issue of disclosure, which was one of the underpinnings of Citizens United, that we'd be protected by disclosure. And the 501c4s were being used extensively to avoid that requirement. So when the president says that this is a problem for our democracy, he is talking about the practice. He's not talking about, let's go investigate Mrs. Engelbert. I mean, come on. Get real here, people. Well, you'd have to show it to me before I'd believe it.
Let me ask a question of Rob, if I could. Maybe take this chronologically. You've mentioned that there are bad apples everywhere in the world, everywhere in life. Are you assuming that the sort of initial actors in the IRS, they were among the bad actors, but they were isolated? And if that's the case, what do you do with all the facts after that, the way the case has been handled by the Department of Justice? Is that just good lawyering or aggressive lawyering, or especially when you get a rebuke like that from the D.C. Circuit Court of Appeals?
So I don't know whether they were bad actors or in over their heads. That's sort of my point. I think what I've seen and what I read from the Inspector General is more the latter than the former, but I don't know. The way the Justice Department handled the case, I can tell you that when you asked the Justice Department to produce information from investigations that they've conducted, their answer is no, almost always. And then you have to try to pry it out of them. And if you think about it, there's good reasons for that in in the vast majority of cases, because the investigative process, grand juries, everything is confidential for a reason. Some cases, it's not appropriate. I'd have to know more about the circumstances of what positions they took in the litigation to be able to judge whether I thought it was appropriate in this case.
Right, and it begins to remind me of Judge Royce Lamberth's exchanges with the Department of Interior, which I think happened under President Bush, where he sanctioned the Department of Interior for their failure to be forthcoming, in his opinion. In the back there, that's Will Hahn. He's also a contributor to the book that I wrote with John Hughes. So maybe that's why it's not selling. Too many people wrote it.
I had a question for you, sir, if you don't mind. You had acknowledged that there was incompetence and sort of, as the president said, boneheaded decision-making going on with the IRS. But I'm wondering what the remedy to that is exactly. Is it just trust us and move on? Because, I mean, you pointed out Attorney General Holder considering only the law in deciding not to defend DOMA, for example, but not even Justice Kennedy bought that. Frankly, if you look at this page 12 of the slip opinion in Windsor, he said that the executive's failure to uphold the law in this case created a procedural dilemma that posed a threat to our separation of powers that wasn't based on any theory that the Supreme Court had announced up to that point. So what exactly are we supposed to just trust? I mean, I'm kind of thinking back to NAACP versus Alabama here. Would trust us have been a sufficient response when the state of Alabama wanted the membership records of the NAACP?
So what I've said was that I would prefer that the IRS not have to make this kind of decision at all, and I think the best thing to do here would be to revise the standards so that they're not engaged in some subjective determination about whether something is 50.1% social welfare and 49.9% political or vice versa. But short of that, all you can do is put in place procedural mechanisms. And there was a recommendation of I think it was the IG of various steps that needed to be taken in the IRS. The IRS said they were going to undertake those. They did undertake them. The IG issued a report that said they were in place and they were satisfactory. If you're gonna make this kind of inquiry part of what goes on, all you can do is put in place procedural protections.
Here in the front.
Can I just
Oh, wait,
very
let's
quick?
go to Hans von
Let me
Spakovsky.
address something on the DOMA issue. There's a long series of opinions from the Office of Legal Counsel, Department of Justice, followed by administrations of both parties up until this administration, in which the OLC has always said that it is the duty of the Attorney General to defend the constitutionality of a law passed by Congress, and the only exception to that has been if it is a law that infringes on the constitutional authority of the president. Okay, the AG who works for the president does not have to defend a law that takes power away from the president. Okay, DOMA was not that at all. And in fact, the DOMA law had been defended by Justice Department lawyers in case after case around the country. In the lower courts, DOJ lawyers filing briefs making very rational, very defensible, very constitutional arguments as to why the law was okay. To suddenly come forth and say there is no constitutional defense is basically saying that before that, the Justice Department and its lawyers were filing frivolous, meritless briefs. Now, I actually happen to know some of the lawyers who filed those briefs, and I can tell you they were highly offended at the idea that they were filing briefs making meritless defenses of that law. This was a pure political, ideological decision not to defend the law. Now, even if you don't like it as a policy, as a public policy, you have a professional duty as the Attorney General and as a DOJ lawyers to defend laws passed by Congress, even if you don't like them. When I was in the Civil Rights Division, there were specific provisions of the laws that I thought were not a good idea, we enforced them anyway. This decision not to defend DOMA was pure politics, had nothing to do with the law.
Well, I'm glad that you're clairvoyant enough to know what was in people's minds, but I was present at the discussions, and I know what was discussed. And it was a legal decision, and the the President, Attorney General does not have to defend a law that is unconstitutional, and the law evolved over time.
Yeah, look, that's just false. My chapter in the book deals chapter and verse, line by line, of the changes that were made in the briefs after this administration came into office that were to set up the false claims that were subsequently made in later cases. Elena Kagan's handprints were all over it. The Department of Justice Attorney General was all over it. There's documented evidence of what was done and conversations and interviews with those people on why they did it. This is not speculation, and it's all documented here in short version and the longer piece I've got at the Ave Maria Law Review. And it's that kind of manipulation of the judicial process that is going on routinely by this Department of Justice that is posing the problem we're talking about today. And I'm not speculating about this. I have documented it chapter and verse of when the draft brief was written, what the change was made, the conversation that occurred about that change. Now, some of it I've then anticipated other conversations that might have occurred to get there, but I've got the very specific changes that were made to set up the kind of claims, and it was things like, don't claim that this is subject to rational basis review. Claim instead that in this circuit, the prior cases have recognized rational basis review, so that when we get to a circuit that hasn't addressed this yet, we can argue for higher review and therefore lose our own position. And that's all documented, and we see that language in the changes in the briefs from one brief to 2 months later when they file a reply brief, that specific change made. So don't tell me that this wasn't done deliberately to undercut the defense of that statute.
Another question here in the front.
Mr. Waddy, your message to me seemed to boil down to don't make assumptions about people's motives and intent if you don't have direct evidence of those motives and of the motives and intent. But it didn't seem like the other side feels like they were making any assumptions. It felt like there were several things that were directly attributed. Like you mentioned the fact that the word patriot might be a shortcut. Well, but you didn't address the fact that the actual process to analyze these applications was significantly changed. If there were shortcuts for patriots, why weren't there shortcuts for, say, liberal groups? Why haven't any liberal groups come forward and said that any of them were targeted ever? Why did Lois Lerner plead the fifth? If it was an honest mistake and you admit it was sloppy, why has no one been fired? So the things that people say are evidence, and this isn't assumptions, what's the counter to that evidence?
Where did you start again?
Well, I mean, for instance, if this was a sloppy thing, why wasn't anybody fired? Why has there been a lockdown? Why hasn't there been, out of the many, many hundreds of conservative groups, why can't anybody find one liberal group? I mean, do you really say
There were
do you really
liberal
say it was a
groups.
coincidence? And what do you make of Lois Lerner pleading the fifth? What do you make of nobody getting fired?
I mean, if anybody who's going before Darrell Iss's committee under those circumstances is going to, if they've got a good lawyer, is going to, I would advise almost anybody to, in those hostile circumstances, to assert the Fifth Amendment. That doesn't, and it's a big decision to assert the Fifth Amendment, but that would be my advice to her without knowing whether she did anything wrong or not. I just wouldn't.
But would it also be your advice to then give 12 hours of interview to Department of Justice lawyers that waive your Fifth Amendment right? And the notion that there's nothing partisan going on there by these Department of Justice lawyers, when she does that, and then, it's just preposterous.
And what about the fact that she appeared before the Congress? She appeared before the ISA committee. The IRS commissioner appeared before the Ways and Means Committee in 2012 and denied that any changes had occurred in the processing of applications because people had started to rumble and talk to their members of Congress and say there's something going on. I started saying there's something going on. And she appeared, she met with the staff. Would you like to know how the TIGTA report was, the investigation, if we can call it that, since Lois Lerner's #1 aide deputy sat in on all the interviews? Did you know that? all the interviews. There was not a single interview that Holly Paz, who was dispatched, deployed by Lois Lerner to sit in on all the interviews that the TIGTA representatives conducted of the IRS employees to try to find out. But the reason the TIGTA investigation was initiated was because Congressman Jim Jordan had been getting these complaints, called and asked, he had his staff ask Lois Lerner to come meet with his staff to find out what was going on. She came over to the Hill, was clearly offended that she was being summoned to have to answer questions, basically stonewalled them, and when she sort of swept out of there, they looked at each other and said, well, we can't go back and say we got nothing. We got to come up with something. They said, how about a TIGTA investigation? And so Congressman Jordan and Congressman Issa sent the letter in 2012 when the IRS commissioner had, now we know, lied, when Stephen Miller, who became the acting commissioner, lied, Lois Lerner lied, denied that there had been any changes in the processing, which we now know is a complete lie. They should all have been prosecuted for perjuring themselves before the Congress. And they asked for the TIGTA investigation. And so 1 year later, then we got what we got. There's more to that. There's more to be, and we now know there's so much more to learn. And all they've done is stonewall. They've not been contrite. If you want to read the pleadings, you can see that while they have been contrite in the public, Lois Lerner apologized and admitted it, and all. That isn't what they're telling the court. That isn't what they're telling the court.
Another question over there on the side.
My question is, to give a little help here, is if these, if it wasn't just Lois Lerner herself, or if there's been all of this political interference, how come we haven't seen resignations from justice amongst the career people? That's been bothering me a little bit, and I wonder if anyone could talk about that, or if I'm just wrong on the facts.
Well, many of the people that I know and who have been sources for me in my stories are people who, they have a nice job. They got a good job. It's tough to fire them. They get good benefits, and they don't want to leave justice. On the other hand, a number of people I know have left or have been driven out. One of the prime people that was driven out by this administration was Chris Coates. Chris Coates was the chief of the voting section, someone who had been litigating voting rights cases for 30 years. He had more combined trial experience than all the lawyers in the voting section combined. He had been given an award by the NAACP in Georgia for the work that he had done down there. But he made a huge mistake with the Obama administration. He believes in the race-neutral enforcement of the Voting Rights Act. He thinks if you're discriminated against in the voting context, no matter what race you are, you've got a case. And he voiced that, and because of that, he was driven out as the chief of the voting section. And in fact, the biggest anger at him, and this is in an IG report, okay, this is not me making this up, this is an IG report released 2013. The biggest anger at him was the fact that he had participated in the first lawsuit that the Civil Rights Division had filed in its entire history down in Mississippi against local black officials who were discriminating against white voters. The court decision by the district court, which was affirmed by the Court of Appeals, said it was some of the most blatant discrimination the judge had ever seen. Now, that was one of only, I think, 17 or 18 Section 2 lawsuits that had been filed by the Bush administration. All the rest of the suits were on behalf of African Americans, American Indians, Hispanics. But because they filed one suit that enforced the Voting Rights Act in that manner, the people coming in were extremely angry about it. He was told by the acting chief of the Civil Rights Division when she found out that he was asking new recruits, people they were trying to recruit, they were interviewing, whether they believed in the race-neutral enforcement. He was told that he should not ask that question. So he was finally driven out as the chief of the voting section. I've written a lot about that, but that's just one example of the kind of things that's going on. Other individuals who did things like the Louisiana case I'm talking about, they were kept on. There's another employee within the Civil Rights Division who the IG said committed perjury when they were investigating the case. She was posting anonymous comments criticizing other personnel within the department, may also have leaked confidential legal data. She was neither disciplined nor terminated. Why? Well, because she has a liberal view about things, and they weren't about to get rid of her.
Could I just say that frequently, usually, when the Department of Justice undertakes discipline against somebody, people outside the department won't know about it. Now, Mr. von Spakovsky may have sources, but generally the fact that somebody is still there does not mean that they suffered no consequences.
Got time for a final question over there.
I'd like to focus on the groups that are at issue here. I'm not a tax lawyer, thank goodness. If I understand the law as it's been explained today, if you are primarily engaged in political activity, you do not, you can't get tax exempt status. Some of the descriptions of the group suggest that they were primarily engaged in political activity. So can you comment on that? Are all of these groups, in fact, social welfare and not political groups? And the second part is, what should, if this process didn't work, what should the process at IRS be for determining primarily engaged in non-political activity?
Let me just say real quick, there's a lot of confusion about this, but what you need to understand is, look, if you're a pure political organization, no, you can't get 501c4 status. You're a 527 organization, and everything you do is reported to the FEC and the IRS. Social welfare organizations, 501c4s, like the Sierra Club or the NRA, they can engage in some political activity as long as it's not a majority of what they do. But if you look at the be on the lookout criteria that was being used by the IRS, political activities when you're helping candidates, okay, that's not what they were looking for. They had all this criteria in there that, for example, if you were criticizing Obamacare, well, that was considered political activity. That's not political activity. If you have an interest in health care, then you're a social welfare organization. The fact you might be critical of one way the government's doing health care doesn't make you fall within the definition of candidate-related political activity. So all the criteria they were using was frankly wrong.
Well, and I think that is I want to give an example of that. The group that the reason I know that this started in 2009, even though all the court proceedings and all, they dated January 2010, I represented a group that we filed the application in October 2009. The IRS cashed our check. You get to pay for the privilege of having them subject you to all of this. They cashed our check in November 2009, and we did not hear from the IRS again. Like I said, remember, I'm used to hearing in 3 to 4 weeks. And let me tell you what, they either get the letter or they'll write back and they'll ask you a question about your application. You only have 1 board member. You need 3. You know, you forgot to submit bios of your board members. I mean, things having to do with the 4 corners of the application, which it ain't a postcard, I might add. And so we submitted this application, and this group spent 100% of its money that it raised between November of 2009 and I don't remember when they really quit, but ultimately the delay, they didn't get their tax exempt status until July of 2013, by the way. And by then they really, the IRS had succeeded in shutting them down. But all they spent their money on was fighting Obamacare. The IRS, when we heard from the IRS about this application, it wasn't from Cincinnati. It was from the Washington office. And we heard from them in June of 2010, and what they asked for were copies of our ads. Every ad that had been run about Obamacare. Now let me tell you what, that is 100% permissible activity. That is grassroots lobbying, it is direct lobbying, it is not political. But one of the things I noticed, and Hans is 100% right here, one of the things I noticed when Stephen Miller right after the TICTA report was issued in May of 2013, he was the acting commissioner. He testified in the next couple of weeks. He wrote an op-ed for USA Today, and he kept using the word advocacy. Advocacy. Well, advocacy, what does that mean? That's not a legal term of art. It's either an expenditure it's either a partisan campaign intervention, that's the legal term of art, or it is an expenditure to influence legislation, for communication to influence legislation. Those are two different things, but they're both advocacy. And when you conflate those things, then you have lost a legal standard. And all I'm saying is that I can give you many, many examples, but what happened was two things. They changed the process to quarantine. They quarantined groups that they thought were going to get media attention and with which the administration disagreed. That's really what they did. And Obamacare, in my view, I just will always believe, based on the experience of dealing with this, that was a trigger. It was a trigger, and because they were worried about all these grassroots groups having an impact on whether or not Obamacare. You'd think after it got passed in in March of 2010, they wouldn't have worried about it. But let me tell you the other thing. Since when does citizen involvement in political activity not serve the public welfare? I mean, for decades, the IRS has recognized that that is part of serving the public welfare. We want citizens to have meetings and invite candidates in, candidates for judges. Whoever goes to a candidate debate of judges, that's the kind of stuff people were doing. They weren't necessarily endorsing people, but they were involved in their community. They took on, they started looking at their city council and their county commissioners and doing things that we say we want them to do. And they were punished for it. And they were subjected to what the court said today was egregious treatment by their government. And to deny that and to say, oh, boys will be boys, IRS agents will be befuddled, I'm not buying that.
Quickly, John.
One other thing. If the real concern was testing whether there was ineligible political activity going on, in the second of the extensive requests for information that True the Vote got, the IRS said, "Oh, by the way, you really ought to put local elected officials on your board because we're so concerned about you being engaged in political activity." I mean, think about that. So I mean, this is extraordinary. And so when I say there's something more going on here, but when you see pretext crap like that on the arguments, there's something more going on. We learn as lawyers to kind of that evidence kind of sometimes doesn't pass the red face test of what they're claiming it's supposed to be. And that we've seen that over. We saw it in the National Organization for Marriage case. They released our donor list at the height of the election, where that issue was the single most important thing. And they blamed it on some low-level clerk out in Utah who never's made a mistake in her life. And she picks the biggest high-profile one to do her first mistake with.
She didn't remember making it.
And she didn't remember making it. And she says, I don't think I could possibly have done that. I never do that. I know my job. And the one guy that knows where he got it, what's DOJ do? They give him immunity from his Fifth Amendment instead of saying, they don't give him immunity that would have required him. Who gave it to you? Was it that accidental clerk, or did somebody else give it to you? Why do you give a low-level guy immunity if you're not going to prosecute him, or not give him immunity, if you're not going to prosecute him anyway, when he's sitting on potentially explosive information that may unravel their whole story? Well, you do that. You see stuff like that, and these are not isolated instances. We're seeing them over and over and over again. And at some point you say, maybe there's a little bit of a pattern here that we ought to be looking at. Thanks.
I'm afraid we're going to have to let that be the last word, although we have a cocktail reception next door. So please join me in thanking the panel.